Good morning. Yesterday we have completed the part 3 fundamental rights and we read article 32 which gives power to Supreme Court to provide a safeguard to our fundamental rights. In this article, there are 5 writs which Supreme Court can be issued according to their needs. That are habeas corpus, second is mandamus, third is prohibition, fourth is certiorari, fifth is quo warranto. Today we learn these writs one by one in detail. We start with habeas corpus. The literary meaning of habeas corpus is to have the body. This writ is issued when there is a illegal detention. In this writ, court order to produce the detained person in the court. If the detention is illegal found by a court, then detainee can free or release from detention. This writ provides a safeguard against arbitrary action of the state or an executive or an individual. Court can issue this writ only in illegal detention, but not in case of if the detention is for the contempt of a legislation or a court. Now come to second writ, mandamus. Mandamus, the literary meaning of mandamus is we command. This writ is issued by court against the executive or inferior judicial bodies to perform their duties. If a inferior court or an executive not performing his duty according to rule, then Supreme Court can issue the writ of mandamus to order him to perform their duty properly. Mandamus cannot be issued against a private person or a president or a governor of any state. This is issued only against the inferior judicial bodies and a executive. Mandamus writ is a commands activity. Third one is prohibition. Prohibition, the literary meaning of prohibition is to forbid. This writ is issued to stop the action. This writ is issued against judicial or quasi-judicial bodies only. Higher court issue this writ against the subordinate judicial bodies to stop them from going beyond their jurisdiction. If a judicial body use the power that is not given by law, then higher court issue a prohibition writ to forbid them from their action. Next is certiorari. This writ is issued against any judicial or a quasi-judicial body by the High Court. Certiorari writ is issued by the superior court to the inferior court. It is issued to quash the order of an inferior judicial body or to transfer any case to itself from the lower court. If higher court think that the lower court is not working according to law or any biasness they feel, then they order the issue the writ of certiorari. This can be done on the basis of error of law, second, lack or excess of jurisdiction issued by court. Certiorari can be used even after a case has been judged by subordinate judicial court. So, certiorari writ can be issued if the court has been given his decision and higher court, when see this is not according to law, then the higher court issue a certiorari writ and dismiss the order of lower court. Thus, it is a curative as well as a preventive. This writ cure the law as well as prevent to the unlawful activity. Next is quo warranto. Literally meaning of quo warranto is by what authority? Which authority provide you this power? Quo warranto ensure the legality of qualification of the person holding the office. This writ quo warranto put a question on the qualification of the holder of the office. It issued in the case of any substantive public office and not against the private office. The quo warranto writ can be issued only in case of public office, not in a private, not against the private office. Quo warranto asks that by what authority you are holding the office. The quo warranto writ questions who authorized you to hold this office and you have to answer for this. With this, we have completed our 5 writs which are issued by the Supreme Court. Thank you. We meet in next video with our directive principle of state policy in Indian Constitution.